Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is your account concerned, or
I am not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt.
I read him.
You just be quiet.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
Love that one. Love that one. Welcome back to the Court of Public Opinion. I am the Recovery Addict. That's where I am, right there in the corner. Fix that. No, that's good. That's good. I'm leaving it right there. That's good. Welcome back. Welcome back from lunch. I had a fantastic lunch. Healthy, diverse lunch. I mixed the what we call quantity cookies, which are vanilla cookies. They're like an Oreo cookie, but they're vanilla and they're cheap. With some chips and dip, and also had the sandwich. I had a sandwich for lunch. It was an ice cream sandwich, but I did have a sandwich for lunch as well. So I think I covered everything there. So it was delicious. Hope you had a great lunch as well. Welcome back. Welcome back. We have lots of things going on during lunch. During lunch, the Superman guy from Las Vegas. Made his little appearance in court before the same judge he attacked just a couple days ago. It was entirely uneventful, and it was incredibly fast. He was wearing a spit guard, and he had all the bailiffs around him. All the bailiffs. It was so quick. It was just one and done, and there was no drama. The judge entered her calendar from that day in the record and saying, "This is why we're starting over right here," and just continued, and he was ordered out, and that was it. It was a nothing burger, but let's see if I can find it. Superman. Let's see. We have. Let me see if I can bring this up. Let's put this over on. Need a different camera. Let's go over here. We'll do it. We'll access it through Twitter because that's going to be fun. So let's do this right here. Go to 3. There we have him. This is how he looked. In court, you can see he's got just a few escorts. His hands were bagged and tagged. I don't know what do they call that when they put your hands in little containers so you can't grab anybody. It's I'm not sure what it was, but this is how it went down, and that's how he stood for the duration of the hearing. Let's see if I can find the actual feed. Let's see. Las Vegas Locally. I think Las Vegas Locally was tweeting out a link to this. Let's go to them really quickly and see if they show us. Let's see. It's in front of the same judge. They're gonna want to play a commercial. I'm pretty sure it was breaking news. We're waiting. Here we go.
Point Hotel Casino.
Yeah, we don't want that one. Nice.
I am making my calendar page from that day an exhibit for the court. As it existed the moment I walked in, prior to anything happening, nothing's been changed, indicating the sentence I intended to impose.
So this is the judge that was attacked. She was the one that was attacked over the bench. Let's see if I can pull this up in YouTube. Hang on one second. Let's see if we can get a full.
All right, that being said, in accordance with the laws of the state of Nevada, this court does now sentence you in addition to the $25 administrative assessment fee, $150 DNA fee, the $3 DNA administrative assessment fee, and $250 indigent defense fee, 19 to 48 months in the Nevada Department of Corrections. How much credit for time served does he have?
It's 0 days. He was on probation when he committed the offense.
0 days credit time served.
On probation to serve the jail time October 25th. That time it expired at or about the time of the plea. So
0 days credit. Mr. Almasi, if that's different, let us know.
Look at all these bailiffs. The guy on the far left is his attorney. Who just didn't watch the attack. Not much he could do.
And for the record, I just reflexively wrote 0 days credit time served on the notes because of what I just said. So
Count the bailiffs. Quick count. That was it. It's gonna pause for a second. 1, 2, 3, 4, 5, 6, 7. I can't tell. There was quite a few bailiffs. That was it. That was everything that happened. So he was very calm considering. He may have been sedated. I don't know. They had all the precautions in place.
You've been watching breaking news.
Yes, we were watching breaking news. Thank you. That was nice of you. Let me get rid of that. But that was a quick appearance out of Las Vegas. So let's see what else we have. Okay. Where was the other one? There was something else I wanted to show you, but it disappeared. Oh, Judge Middleton. Judge Middleton's up. What's he doing? Why is he gone do not record on us? Why is Judge Middleton, our favorite ponytail judge, now not wanting to play the game of public broadcast? That sentence, it was 18 to 48 months. So he's going to get locked up for 18 to 48 months. So it's like a year and a half to 4 years. But he still has to face the other charges. A new game, guess the number of bailiffs. At every court, we're seeing pretty much an increased bailiff presence now. Let's see. Let's exit full screen here. I don't know where we went. Okay, we'll come back to that. All right, where are we here? We're right there. All right, welcome back from lunch, by the way. Hope your lunch was fantastic. Let me see. Krista. First in chat right here. There you are. Thank you for being first in chat, Krista. Every time you're first in chat, we punish you with internet ownership, and here you are first in chat again. Some people just don't learn. Thank you, Krista. Appreciate that. The internet is all yours for the rest of the day. Ulala Pat says, lurking since early last year, member for 2 months, just to say, y'all rock. RA moderators and community. Thank you very much. Appreciate the kind remarks, and thanks for being a member as well. Someone was just walking behind me. I don't know who it was. All right. Hello, Brandy. Brandy, are you here? I thought I saw Brandy. There she is. Boom. Late. Brandy, hope you're feeling good or feeling better. Thoughts and prayers to you. If anything we can do, please let us know. Honestly, if there's anything we can do, please let me know. Let's see. I saw the original about 20 minutes after it was posted. He attacked after saying he was ready to go back to society. Oh yeah, he was saying, I always do, think what's the best thing to do in this situation. That's what I always do. And then he demonstrated that by attacking a judge over the bench. All right, Buffer, Red Pen gifted 5 memberships. Krista gifted 1 membership. Thank you, Red Pen and Krista. I see 80s Music Man somehow managed to not receive them. But that's wonderful. Rebecca Rams, is that Rhymes? Rebecca Rhymes or Reams? Welcome to the gallery. Love that yellow courthouse by your name. Thank you. And Ivan Victor says 11 months. That's how long a pregnancy lasts, right? Ivan, you're going to get yourself in trouble. I hope so for my parents' sake as it relates to the marriage. No comment. Let's see. You're trying, says Red Pen. Thank you very much. Bug Dugger has been gifting memberships as well today. Just gifted another one right now. And that one went to Krob. Congratulations, Krob. All right, we have a couple things. We've got a few courts to watch. We are watching some courts that we're waiting to start, but they're not ready yet. I wish we had a trial that we could be dive neck deep in and wade through. But currently, we're waiting for trial to start, so we're still jumping around the country a little bit, looking at different smaller courts, and sometimes finding things that are quite interesting that may be telling. We're going to jump back up over to Thurston County really quickly, right here.
Right now, that'd be helpful.
It is. Everyone ready?
Oh, we're ready.
5306.
I'm not sure what he's saying here, so I'm going to turn it off. He might be giving his address.
JBLM. 9851.
Still giving numbers. We're going to turn those off.
6A.
There we go.
5306.
Yes.
Okay, thank you. All right, so what I'll do is I'll set a hearing for Tuesday, the 6th of February at 10 o'clock in the morning.
You said February 6th, Your Honor?
For February 6th at 10 o'clock, and we'll mail notice to you at that address. And do you receive text notices from us about your hearings?
Yes, I do, Your Honor.
Okay, we'll also send you text reminders of that. So you should get plenty of notice, February 6th at 10 o'clock.
Okay.
Are those being scheduled as
I'm scheduling
by hearings?
As a review hearing.
Review hearings? Okay.
Yeah.
And one other thing, Your Honor, I did notice that Mr. Rogers has $213 of legal financial obligations owing. I did speak with him. He mentioned a little bit to the court about having new housing. His wife is military. They're on base now. They do have 2 young kids, ages 1 and 2, and Mr. Rogers is not working himself. So their budget is very tight, Your Honor. I just asked the court to consider waiving those fines, or we can address it, at a later hearing. I know the stipulated order of continuance goes till April, but I just wanted to make the court aware that he's not able to afford that at this time.
Right. Yeah. Given the fact that Mr. Rogers is actively engaged in treatment, and I'm satisfied that he is, I will waive the financial obligations related to these cases.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Thank you, Mr. Rogers. We'll see you in about a month and find out where we go on the case. Okay.
Okay.
And Mr. Rogers, or Your Honor, could I get a breakout room just so I can get his contact information?
Let's just do it this way. Mr. Rogers, what's your cell phone number?
76.
No, we're not going to do that, Mr. Rogers. As much as we all want to call you, it's not going to happen right here.
76.
Yes, his number is 76. That is his number.
Thank you, Mr. Rogers.
Thank you. Yeah, have a wonderful day.
The judge is like, no one will be watching us. Just go ahead and read off your cell phone number right now. I'd be like 8675309.
Does Langley have a matter ready?
Yes, Your Honor. If we could call Miss Scott Sherrill.
Miss Scott Sherrill is currently suffering an eclipse.
Sherrill? You with us there?
Yes.
Okay, very good. Thank you. Ms. Langley, what are we doing on this matter today?
Well, Your Honor, we are on for confirmation of trial. I know, and I believe the city knows as well, that she's been in treatment for quite a while. I think the last 2 times she zoomed in, she had a treatment provider with her. I don't have that information, and I think that information is critical, either to the city or if she were to plead to the court. So I'm asking not to go forward with the trial that's current that we're confirming. We can either file a waiver. I know it's an old case, so I haven't been on it forever.
Don't go forward with the trial they're confirming.
Just strike the trial, and I guess that would be my preference, and just file a waiver, set another date, maybe a disposition date in about a month, and I think we should be ready to proceed. So that's kind of my thought on how to go forward.
McClellan, any objections?
No, I know. Yeah, this is Mr. I think Caleb John Vandenbosch was on this case. previously, and I do recognize she's been in a program for some time, and I'll know part of the discussion of resolving is kind of open sentencing. May not have an agreement on, and so I support Ms. Langley having the opportunity to make sure we are aware of all that she's done. But I'd ask for, if possible, maybe not lengthy continuance, just given where we are in this case from 2020, but no objection this time.
Thank you. And Scott Cheryl, are you still at 1420 17th Street?
We're not going to give away everything. This judge is all about just posting people's private information.
Scott Cheryl? Is that Ms. Scott Cheryl? Is that the correct address?
She also has a new phone number, and I wasn't able to hear it correctly. So hopefully maybe we can.
All right. So Ms. Scott Cheryl, you're muted. So if you can unmute your phone.
She's muted and she's frozen. You can't give her a bench warrant, Judge. She's in frame.
And she's frozen.
Yep, she's frozen.
That's what it looks like.
Let it snow. Let it snow. Galaxy 22 Ultra is also frozen.
Okay, so you're going to file a waiver today, Ms. Langley?
Yes, but really, I'm going to send her a chat and see if I can get her phone number because she has a new one.
Ms. Scott Cheryl.
And she's gone.
We lost her. We'll see if she joins us. Okay, anything else ready at this point in time, Ms. Langley?
Well, let's see who we have here. Some of these people may not need to speak to me, Mr. Knox. I think that's just a question of treatment proof.
Colton Knox present.
So
yeah, 1 second.
Okay.
Chad McClellan does the uncomfortable shuffle. Let's see what happens with this case.
Trying to turn my camera on.
The judge is like, yep. We've been fighting this battle for years.
Okay,
Teaching people how to use Zoom.
we have Mr. Knox.
Hair looks great, dude. Hair looks great. You're good.
All right.
If you asked a question, could you repeat it?
I haven't asked a question yet. I'm just reviewing some information right now.
He's like,
and looks like Mr. Knox was in drug court. Is that what I'm seeing here? Are you still in drug court?
Yes, I have 94 days before I graduate, Your Honor.
Okay. Can you make sure they give us some report, because it looks like we haven't had a report for a while from drug court.
Yes, I can do that. My counselor's been on vacation, and there's been stuff he's had to deal with.
Right.
So he's the only one that can write my reports in the program, since he's my personal counselor.
Okay.
Judge is just happy to be here. I think he's the happiest Zoom person I've ever seen. Scott Cheryl is tapping away on the phone. I think she's texting on the phone right now.
And it looks like there was a recommendation back in July for domestic violence treatment. Status of domestic violence treatment, Mr. Knox.
Yeah, so I got my evaluation done, and it's turned into the probation and to the courts. On that evaluation, it said that the lady recommended that I waited till after drug court to start it, so that way I can focus on finishing drug court.
Is drug court like a treatment center? Self-reporting drug court status is discouraged. Colton Knox is used to Zoom meetings being a little more happening than this one. So the awkward silences for him, he's wondering if they heard him or not right now. Everyone's just in there staring at the screen. Whose turn is it? Whose line is it anyway? Somebody needs to talk right here. Does the first person to talk, do they lose? They're all winning right now. By far, the front runner is Galaxy S22 Ultra. Knowlton Knox is like, are we going to sit here for the other 92 days until I'm finished with drug court? Is that what we're waiting for? Are we waiting for me to finish drug court? Or for my counselor to get back from vacation and file a report? I swear, Chad McClellan, he's doing nothing. He's just sitting there. Ms. Langley, she doesn't know what's going on really either. She's completely distracted. If the District Court 2 camera on top keeps getting selected, that means somebody's walking around the courtroom, maybe a bailiff or something making some noise.
It looks like we're here on a stipulated order of continuance from the 8th of May of 2022. So we're 20 months in on that. And Ms. Langley, it looks like with drug court not expected to end for another few months, so we're going to need to extend the SOC to accommodate the need for DV treatment after that. Is that your understanding?
Yes.
Okay. Mr. McClellan, any objection to taking that approach? Extend the jurisdiction in this case for an additional 2 years to allow for completion of DV treatment as recommended.
Now, if there's with a finding and agreement of defense to do that, I acknowledge, I think we were realizing we're going to have to address that time frame. Last I noted he was potentially going to resolve drug court, I think in November, January, so could have transitioned, and that's where we were set today to see. I haven't gone too deep into the drug court docket to see. Regardless, it looks like he is in compliance, and his next review is the end of this month. And I also acknowledge that the DV treatment evaluation had indicated that transition should take place after drug court. So I think that's going to be unfortunately necessary to extend the SOC, but he's in agreement to do that, to allow for that, given the posture of his other cases. So with the finding of good, however we need to extend that, the city's in agreement.
So the short answer is no objection.
So what we'll do, because there's not going to be the possibility for Mr. Knox to complete his DV treatment within the current allotted time, extend jurisdiction in the case through May 10th of 2025. And I will note that in this case, upon completion of the DV treatment, the court would be open to Mr. Knox at that point submitting a request for early closure of the case. Ms. Langley, any objection to that approach?
No, that makes sense, Your Honor. Thank you.
All right, Mr. Knox, you understand what we're doing?
Yeah, so you're just extending the SOC so that way I can finish the DV treatment. Is that
Yeah, you
correct?
said what I said in a lot fewer words, so good job. You clearly understand.
You win. Ding, ding, ding.
Okay, so that's what we're going to do. We're going to let you continue following through with your current course, which is complete drug court. And then, the longer you wait in getting back in or getting into DV treatment, then the longer the jurisdiction of the case will go. So the sooner you get in, the sooner you'll be done.
All right, perfect. Thank you.
All righty. Thank you, Mr. Knox.
All right, you guys have a good day.
Yep, bye.
Mr. Knox, it's actually a bad sign when you know all the short acronyms.
Your Honor?
For all the
Yeah,
drug
the
court.
person who's been here since the beginning of the morning, who's just showing, who doesn't have a name showing, I believe that's Robert Seilstadt. And he's showing his Galaxy 322. And I don't think he has a hearing. I think he's in compliance with everything. I can find one of his case numbers if that would be helpful.
If he's not on the calendar, we won't worry about it.
All right.
It's just some random guy here on Zoom hanging out with us in
Let me
court.
look. I think Miss Scott Sherrill just put her phone number in the chat.
Why don't you announce it for the
See
world?
It might be direct to me. Miss Scott Sherrill's phone number is 25.
No, don't. I was kidding. Miss Langley. Yes, we have a Zoom auditor who's present. That's right, Greeners. Maybe it's one of those people that's ordered to attend court periodically, so the judge can just make sure.
I do
they're
not
still
believe
good.
I have anything else, Your Honor.
Morning for you.
The judge is like, yeah, he's good. He's not
Mr.
hurting anybody.
Swenson, anything?
I don't believe so. I believe we've handled all the Pacific Point cases, Your Honor, that I'm aware of.
Okay. Thank you very much. Have a good day.
You too.
Thank you. And
Attorney Kelsey.
Ms. Alt, good morning.
Good morning, Your Honor. I am here on Mr. Nuno.
Okay, thank you.
Whoa, how did you just warp? Is she an AI? She just warped back, like changed size.
Mario Nuno.
And Your Honor, I do have permission to appear via 3.4. We are asking for a continuance. He was hospitalized, which I mentioned at the last hearing. He recently did get out. So I'm just wanting him to complete some classes so that I can negotiate further with the prosecutor. And I did file a waiver this morning.
We're all set for the 17th. With that waiver, and you want that reset? Well, we've set it for trial a number of times. So I think, Mr. McClellan, if there's no objection, we'll strike the current trial dates. We'll reset a confirmation trial date with a potential resolution at the confirmation hearing.
Yeah, no objection.
Okay, with the waiver filed, we will reset. Ms. Alt, if we reset, say within 6 weeks, is that sufficient for your purposes?
Yes.
Okay. So actually, if you'll make a note that we'll want to reset the confirmation in about 6 weeks.
Okay, will do.
All right, thank you. Anything else, Ms. Alt?
No, Your Honor, thank you.
Thank you. Have a nice day.
Thank you, too.
Yep.
All right, Judge, it's just us and Galaxy S22 Ultra.
And Mr. Irinella, good morning.
Good morning, Your Honor. How are you?
Excellent, thank you. Happy New Year.
Happy New Year. I'm here for Sheila Moenboa. She's also here via Zoom.
All right, thank you.
Come on, Sheila, come on down. We'll just push
And
S22
Ms.
aside
Moenda?
so you can sit there.
She's sending me chat, so I know she's here.
Yep, there she is. She's joined us now. Ms. Moenda, good morning.
Good morning.
Okay, let's see.
S22 does not approve. The auditor is disappointed in the framing of this picture.
We had a
And it's
motion.
going to be a continuous request, Your Honor. I was hired leading up to this pretrial date. So I need time to work on the case, and I've referred Miss Mwendwa to get a alcohol drug eval.
Okay. Thank you.
Is there any other career where you can just say, I'd like to not do my job yet. I need more time to do my job. I just haven't had time to do my job. And it's like, cool. Boss, in this case, judge, like, all right, cool. It's all right. Yeah, we'll give you, what, 90 days? 90 days?
I'm assuming this is based on the new county case?
Yes.
Okay.
Consultant.
And there's a pretrial on that set for the 16th. All right. Mr. McCall, any objection to, at this point, entering a denial and resetting approximately?
He's not going to object.
I'd say reset 6 weeks to allow the state case to play out a little bit.
Waiting for Judge Boyd to come back.
Because I believe this case came in as a backup, and so bail was set on that calendar. So she's out on bail, tracking those new charges. So yeah, it just has to be set that to a time frame that makes sense. I think that is appropriate.
Okay, thank you. And Ms. Mwenda, let me confirm a mailing address of 6525.
Man, what's with the personal information? We're just going to bail on the Thurston County right now as they try to dox everybody. We're just going to go straight to Judge Boyd's courtroom. They're back from lunch here.
This is Mark's. Thank you.
Guess what? Something went wrong. So now we have to go back to Thurston. Well, we figure out what went wrong. She's live. Wait for it. Video has been removed by the uploader. Oh, she went live and then went live again. I think that's what the case is. Oh, she canceled it. So now she's not live.
Good morning again, Your Honor. I'm here for Mr. Kinak.
Thank you. One Kinak.
Currently playing Call of Duty. If we could speed this up, because my team
Yes,
is about
I'm
to
here,
drop
Your
into
Honor.
the hot zone.
Good morning.
Good morning.
And how do you pronounce your last name?
Kinak.
Kinak. Okay. Thank you.
Yeah.
Here on the first pretrial. Looks like we have confirmation set for the 12th of February. We do have a pretrial services violation filed. And let's see what the story is there.
I can provide some record on it as well, Your Honor.
All right, hold on just a second. Let me take a quick look at it.
The judge prefers to read at 1 mile an hour, if that's all right. The galaxy ceiling looks sharp. Is that an LED light? Looks like an LED. The refresh rate is high enough that it's not causing problems with the camera, though. Judge Boyd's live stream dropped right after she started it, less than a minute in. So we're seeing if she can get that refreshed, get started again. I'm not sure if she knows that it's down. The judge must have like a 30-inch monitor in front of him. He like reads like this. Welcome back, Mama Grandma. Of course we missed you. But you're here now, so we don't miss you anymore. Al, thank you. Welcome, welcome. Great community. You're part of it. All right. While we wait for something to happen. Oh, hey, whoa! What are we watching here? What show is he watching?
Right. What we have is a violation filed by pretrial services for positive UAs for THC on the 11th and 13th of December.
Now we have a hat in court.
Interestingly enough, or interesting is probably the wrong word. Notable to me is the fact that the screening from the 13th of December was a little more than twice the level from the 11th of December. So that would seem to indicate not declining use, but ongoing use.
Oh, it's invite a friend to court day.
Well, I asked the court to know that these are carboxy THC levels and not active THC levels.
Mm-hmm.
The carboxy metabolite, I believe, is stored in fatty tissues and can be released if fatty tissues are burned off, and not necessarily relate to direct consumption. Mr. Andrews passed on some, who's the attorney of record, passed on some literature to look over. I can forward that on, or we can set another hearing date to review that material. But basically, there's no active THC. So, and I believe active THC lingers long enough in the body that it would have, if he had consumed between these two tests, they would have shown positive for active THC as well as the carboxy THC, which is the inactive component in the metabolite of THC, but can be stored in the body for an excessively long period. So I think Mr. Andrews' argument and my assessment is that this is consistent with prior use, not ongoing use.
So thanks for sharing your science experiment with us.
And I don't see that we have any further UAs yet, even from pretrial services.
Just admit he failed his test. That's what the judge is saying.
When was the last time you did a UA for pretrial services, Mr. Keenak?
I did two the last week of December. I believe it was the 27th or 28th. And I did one after the 13th, I believe on the 14th. That was negative, and the past two have been negative as well.
I don't have any file results from the ones you did at the end of December, which tends to tell me that they weren't positive.
Yeah, they were both negative, and then the one that same week was also negative.
All right. Judge Boyd is back. So as soon as this
Mr.
attorney...
McClellan, I'm inclined to just note those positive UAs, but take no action at this point.
Yeah, and I don't
object.
I mean, I guess I would trust that there were further positive UAs of concern that pretrial services would have filed those. But I think it's, the concerns there, obviously given the history, and I believe he's on a SCRAM device, so that's at least monitoring alcohol consumption. So yeah, with the additional information that's been provided, I agree that's the appropriate or reasonable response today.
Right. And your next due for court on the 12th of February, you were aware of that, Mr. Queener?
Yes, I got notice of that, but Mr. Compton is going to talk to you more about that.
Yeah, if the court wants to just set to that date, I think that would be fine. I'm covering for Attorney of Record Nick Andrews and Ms. Lazarek. They're both unavailable today. Ms. Lazarek because of the Alaska Airlines grounding, and so they're scrambling for coverage. I did excuse the trial waiver and file that with the court if the court would like to set a new pretrial. Otherwise, if the court would prefer, we can keep the standing trial readiness and set to that date.
That attorney just said...
We'll just keep the 12th of February, so 11 o'clock in the morning on the 12th of February, Mr. Keenak, and if, we'll see from there whether you go into trial on the 21st of February or there's some other resolution.
Okay, we're going to go to Judge Boyd, but that attorney literally just used the Alaska Air...
pretrial services UAs, that's important, and
grounding.
Make sure you're not using. That's important.
That's important.
Yes.
CPS worker.
All right. They use the Alaska Air story as an excuse for why I can't be at work. Yeah, my plane was a 737X, whatever it was, I forget. And it's grounded. It's one of the 171 planes in the U.S. that's grounded, so I just couldn't make it there.
Okay. I might have to walk them through it, but hopefully a few minutes.
All right, sure. Just let me know whenever you're ready.
I think that's 3 years. Sammy, isn't this deferred?
My client is downloading Zoom right now.
No, I guess the most recent that I have is that CPS is still involved. The grandma said there's still a no contact with CPS. We have a no contact, so she'll talk with us when we feel.
Yeah.
So we couldn't agree to anything today. So if you want to.
Okay.
Because even specifically asked her thoughts about changing to no contact from to no harm. She said nothing really should want to change.
Nikki, Judge Carroll doesn't routinely broadcast his court other than Zoom, which we can't rebroadcast. I mean, like they don't have like a YouTube channel. It's a Zoom you dial into, and we can't use that for Zoom for YouTube. Oh, here's the walk of shame. Shuffle, shuffle, shuffle. Left, right, left, right.
They can roll one. Yes, I will.
That's a lot of inmates altogether, with no bailiffs visible, I might add.
Oh, yeah. No, not at all.
Thanks.
Yeah.
See you, Zach.
Yeah, I'll see you guys. Easier than that.
Where are we at, Judge?
All right. We will officially take you off of the milk carton.
Yes. Yes.
Nobody knew where he was. He was just missing.
You're staying where?
Does somebody want to give the inmate some tissue? On the end.
Yeah.
It's like the lettuce.
No, it's digging for gold.
He's picking his nose. What?
It's like
It was like.
you were talking about.
No. Are you ready?
Yes, Judge. The court will hear it. We're ready on Montemayor.
All right, Montemayor. And she's only proceeding on one case, correct?
That's correct, Judge, on the UUMB.
All right, court is calling 2021 CR. Does somebody want to give him some tissue? He keeps.
I give him tissue.
Okay.
He keeps what, Judge?
Court is, thank you for, I'm going to stop looking that way. Court is calling 2021 CR 9483, State of Texas versus Justine Montemayor. Can I have parties announced for the record for the state?
Hey, Wilkins for the state.
Nathan Slimane from Ms. Montemayor.
And are you Ms. Montemayor?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Counsel, on this case, I see there's an application. Did you do a application?
Yes, Your Honor.
All right, for some reason it's missing. Ms. Montemayor, did you review a document entitled Application for Community Supervision or Deferred Adjudication with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
All right. Do you mind
We
completing?
can do another one, but.
All right, and we can do it after the plea.
Okay, Judge.
Next, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We wish.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Montemayor, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you cite it in all the appropriate places?
Yes, Your Honor.
I'm going to need you to speak up for the court reporter.
Yes, Your Honor.
Did you understand you're charged with the offense of unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your
Thank you. Ms. Montemayor, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's to be a $400 fine. State recommends deferred adjudication. They're taking in consideration 2021 CR 9484. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, sir.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No motions.
Then I'm going to show you what's outside the agreement. State is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 120 hours of community service restitution, no contact with Brandon Garcia and Sarah Herning, Herning. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence
Your Honor, I offer State's Exhibit 1 in the attachments.
Without objection.
showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
All right. This lady's being super polite. Don't know what the charge is. Sounds like when they say that the plea is taken into consideration that she reads another case number, that means there's a prior, right? So this is not a first offense. It might be the first offense of this nature, but there's something else that they've taken into consideration here. So we'll see what she finds. Good court cases are coming. They're coming. It's just early in the year. We're waiting for things to kick off. Lots of reading here for the judge.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
We'd like to proceed today, Your Honor.
All right, anything you wish to say on behalf of your client?
No, Your Honor, other than respectfully would request that the court honor the agreement that the state and I have worked hard to come together.
All right, and I see that she was previously found incompetent.
That's correct, Your Honor. She's since been restored to competency.
All right, Ms. Montemayor, do you have any support?
Yes, Your Honor.
All right, who is your source of support?
My mother.
And Ms. Montemayor has a treatment plan that been put in place since she's been in magistrate court. So,
and what is the treatment plan?
She's going to be living with her mother, and I believe that there's a network in place for her to be connected with services and whatnot.
When's the last time you had employment, or are you on SSI?
The last time I had employment was probably last year.
Okay, and what were you doing?
I worked at Jack in the Box for a while.
Okay.
It's a fast food restaurant.
And
Burgers
does your
such.
mother want you to stay with her?
Yes. Yeah.
I've been in contact with her mother, Your Honor. She's eager to take custody of Miss Montemayor.
All right, and what's her mom's name?
Tammy McNabney.
Tammy, how do you spell the last name?
Capital M, lowercase c, capital.
Wait, I'm sorry, M?
Yes, ma'am. McNabney.
Okay. And who all lives in that home?
It's my my mother and my 20-year-old daughter.
Okay.
And my dad's gonna pick me up when I get out of the jail. So my dad's gonna take me over there.
Right. And what's the mental health diagnosis?
Schizoaffective bipolar disorder.
Okay. And are you on any type of medications?
Yes, ma'am. I'm on Abilify.
All right. And what's the plan for continuing the medications?
I'm gonna get with the Center for Healthcare Services as soon as I get out of the jail. I just had my because I do the monthly injection.
Mhm.
So I just had my injection yesterday, and then so I'm not due again until next month.
Okay.
It's tough. She looks like
All
she's
right.
doing
This
well.
is what the court is going to do. Court is going to sentence you to 3 years deferred adjudication. There's a $400 fine that will be probated. MIC and TAP evaluation, out of custody. And of course, if TAP recommends inpatient treatment, we'll start with supportive outpatient treatment to begin with.
Thank you.
Take in consideration 2021 CR 9484. Defendant is to reside with her mother. So what that means is once I say you to reside with your mother, that's where you stay.
Yes, ma'am.
If there's some sort of emergency, of course, if you end up getting kicked out, then the court understands, well, immediately you have to go somewhere else. But if that were to happen, you need to call probation on the next business day. You understand?
Yes, ma'am.
And you cannot leave that location without the court's permission otherwise. Do you understand?
Yes, ma'am.
So she's to live with her mother, Tammy McNabney. There's to be regular reporting by Zoom or in person. There's to be a referral to Center for Healthcare Services. There's to be no contact with Brandon Garcia or Sarah Herning, Herning. There's to be regular UAs, field visits. There's to be field visits until she is on the MIC caseload. And I think she should be on the MIC caseload if she was previously incompetent, so there shouldn't be an issue with that. And counsel, if for some reason MIC doesn't accept her, just come back to court and I'll change that because that's very strenuous.
Thank you, Judge.
Let me see. I'm not going to order community service hours because I think the main focus here is she needs to get her mental health under control.
Good job, Judge. Good call.
Probation. Is there anything else that's needed?
No, Judge.
All right. Is there anything else you need from the court to be successful?
No, Judge.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. We can go off the record. So counsel, the case that was taken in consideration, I don't know if she was previously referred to or if you looked into whether or not mental health court would take her. But if mental court is willing to take her, and it would be with Judge Ron-Rangel, if they're willing to accept her, they'll accept pretrial diversions, of course. But if they're willing to accept her and you want to file a motion for new trial, you can probably discuss that with the state and see if they would have any objection to that.
Okay, Judge.
All right,
Thank
but
you.
that will need to be done before the month is out. All right, is there anything else? All right, good luck to you.
Thank you, Judge. May we be excused?
Yes.
Thank you.
Andrew Arnett? All right,
Judge
we'll wait
Boyd
on
is
that one.
incredibly fair.
present, Judge, but we're still conferring
Okay,
with the state.
all right, and then Brandon Lopez? You have Espinoza?
Yes.
Okay.
He was with us before.
Just one moment.
He returned. I recognize him from this morning. I forget what he did.
All right, after we're going to go back on the record. In 2023 CR 5393, State of Texas versus Joshua Espinoza. Can I have parties reannounced for the record, please?
Jason Garahan, Your Honor, for the state.
Brandon Lopez for Mr. Espinosa.
And are you Mr. Espinoza?
Yes, ma'am.
All right. So I asked that this be recalled back because there are things that I wanted to think over to consider. Is there anything else from either side?
Nothing from the state, Your Honor.
She's going to throw the book at him.
All right. So Mr. Espinoza, what I want you to know is I always see people as individuals. I always ask people about their tattoos, right? But I don't hold tattoos against people because some people want tattoos for different reasons. Some tattoos are for gang signification. Some tattoos are for other things. But I'm not holding that against you. But I always want to see if there's something that can be done to help somebody if I'm strongly considering probation or if not. So I wanted to take a break because we were very busy this morning to think about your case. And I did think about your case. The problem is your criminal history is extensive, right? And there have been some times where you were given probation and your probation was revoked. So I'm not going to grant your application for probation. I think your attorney negotiated a good agreement for you, okay? But what I can tell you is at the prison, if you want to, I can request the therapeutic community. Whether or not you get in that program or not, part of it is going to depend on you because I can't force them to place you in the program. But I would be more than willing to write on the judgment and on my docket sheet that I believe that there are some mental health issues and also some drug issues. So they'll probably be willing to help you with that. Do you understand?
Yes, ma'am.
All right. So this is what the court is going to do. The court is going to find you guilty as previously stated. The court will sentence you to just 6 years in the prison, give you credit for any time served, and I'll do a request for the therapeutic community. And I'll note that defendant has mental health diagnosis and drug addiction. All right, is there anything else with regards to sentencing?
No further.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to the attorney. Do you understand?
Yes, ma'am.
All right, we can go on the record. So do not get institutionalized at the prison. Try to better yourself so you don't end up back in that situation. Good luck to you, okay? All right, who's ready? Anyone ready?
Paperwork good on Fuller.
Fuller, okay.
Fuller, Judge.
Fuller? Thank you. All right, come up on Fuller.
Step right down.
This one, right?
Nope, other side. Other side.
Judge, I'm a little hoarse, so.
Okay, oh, and you're on this side now, Council. That's dismissed.
Just cause? Just cause?
Oh, no, the deputies asked that be moved around for security issues. So I always tell people I try to stay in my lane, and that makes their job easier, so. All right, and Deputy, Mr. DeLeon, can you move your client to that end? Thank you. All right, court is calling 2023 CR 7913, State of Texas versus Marie Amanda Fuller. You have parties announced for the record for the state.
Hank, welcome to the state.
Defense.
Louis Martinez on behalf of Ms. Fuller.
And are you Ms. Fuller?
Yes, ma'am.
Counsel, have you received all the discovery and did you review that with your client?
Yes, ma'am, I did.
Court will find that the state is in compliance with discovery. Ms. Fuller, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Sure.
Ms. Fuller, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
You wanted a PSI?
I do, Judge.
Okay. All right. Can I have a date for a PSI? All right.
I'm sorry, it's the 15th, not 16th, the 15th.
All right. It'll be February 15th for the PSI. All right. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, yes.
Do you believe she has a rational as well as a factual understanding of the charges against her? Do
Yes, Your Honor, I do.
you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Fuller, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Very much.
Are you a U.S. citizen?
Yes, ma'am.
All right. Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $500 fine. State recommends community supervision, and there should be ignition interlock for half the term of probation. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there been any such motions?
There have been none.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 10 days in the Bexar County Jail, and 100 hours of community service restitution, the DWI intervention, and VIP. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor, I offer State's Exhibit 1 and attachments.
That's without objection, Judge.
All right, State, you can continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Thurston's back. Galaxy Man is gone. Let's see. We're gonna jump to this.
A month. I don't know what the reasonable time is going to be to have those assurances, but also, willing to look at the scram after maybe some period of treatment. So I would ask if nothing else that the scram device remain. I mean, I think that does seem to be a safeguard that needs to be in place to make sure no drinking is involved. I do see that history as well, the court's referring to, that gives the city concern, but I recognize there's quite a gap in between. So I think assuring that there's no alcohol consumption is going to be important. I did prepare an order with those current exceptions. If the city's open to other exceptions that seem to be reasonable to help. I don't want it to be too much of a burden on Miss Double Runner or the family, but I think at this time it's still fairly, a fairly recent event to maybe go away from it altogether. So I'd defer to the court on what other exceptions may be appropriate. But the city's position is certainly to keep the scram device on at this time.
Mr. Double Runner?
I guess recalling back to the first two instances, you're talking about the protection order or no contact order. The one in 2009 was simply a childish attempt on my end to get a protection order against then Miss Ross. That was more or less a derivative from a previous relationship where my ex would put a protection order, drop it, put one on, drop it. And so in the mindset of coming from that past relationship, I thought I initiated it. And then we went into family court, and then family court looked at my record and said, no, you're not getting a protection order. Canceled mine, gave Shayla to Miss Ross and imposed the protection order, which Miss Ross a week later dropped because that was not her intention. She was there as the respondent. I initiated the 2000. It should have been the initial. You said 2012. I believe that's when I resolved the probation. But that initially was a Mr. Sabota kept me in and out of court for over 6-8 months between being stuck in Nisqually jail and having Thurston County probation, no bail warrant. He wouldn't drop the no contact, or he would not drop the domestic violence charge unless I pled guilty. Your Honor, you were there the day I pled guilty to that malicious mischief. He asked for no contact order, no domestic violence treatment, no probation. He just simply wanted me to plead guilty to domestic violence. I was 2 miles away from our home walking to the emergency room when the Lacey Police Department pulled over at midnight and accused me of fighting multiple guys on our street that we lived on after they found out where I lived. So both of those are kind of debunked in the sense of us having, I understand on paper it looks one way, but explaining it gives it a little bit more light on the subject. I have got into drug and alcohol treatment. I am subject to random UAs with Nisqually. I hope that they submitted that paperwork with the city of Lacey. I'm happy to keep the scram bracelet on. So we just need to kind of find an amicable means to move forward so that my household can, move together, I guess.
All right. So Kelly has told us that it's your drinking. It's your drinking that's been the problem.
I agree.
So talk to
you. Well, I would say this is the worst thing for me to happen. I've got sober. I've had the scram bracelet on. It's, I see light at the end of the tunnel. So I'm fully committed to continue this with or without the scram bracelet moving forward. It's not for me, it's for my wife and my kids.
So you see the impact that your drinking has on the family that you live with.
Yes, most definitely.
I mean, it's not just the fact that, you know, and I'm guessing, I don't know, but I'm guessing that when you drink, they probably get afraid of you.
I would agree.
And you know, I can't imagine a father being in a position where, you know, there's any sort of satisfaction in having family members be fearful of. That's the last thing is a dad any of us would want in my mind. And that's what you do when you drink.
Yeah.
And, you know, it just strikes me that, you know, Kelly's here after knowing this history, and she's still back here asking for you to come home and just indicating that it's your alcohol that's been the problem. So it's amazing she's willing to take you back, frankly, given that history of you know, alcohol being a problem in the past, and once again, it was a problem. So I'm surprised by her willingness to do so.
I could agree.
Yeah. Okay. All right. Based on that request, I'm going to grant the request to rescind the no contact order. You will continue to wear the scram device. We're going to do everything in our power to ensure that you are not using alcohol, because everybody seems to agree for you. That's the thing that sends you off in the wrong direction and frightens the heck out of your family. So,
okay.
Mr. McClone will submit, he already has a rescission of the no contact order. Let's see, right now it says it's read only.
I think I had it open. It should be available for the, just for the court.
Yes, I just reopened it.
Order in the court. Order.
Okay, Mr. Double Runner, at Kelly's request, I've rescinded the no contact order. Like I said, all the other conditions, specifically the alcohol related conditions, still apply. So I've, you know, the first hint that, you know, if you come up positive on the scram, or you know, have some other indication of alcohol use, then that no contact order is going right back into effect.
Understood.
Okay. And as I said, your next court date is the 26th of February. So you said you're going to have counsel hired by then.
Yes, sir.
The charge doesn't go away just because I've authorized you to go home. The charge is still there, and it's up to the city to pursue the charge. It's not Ms. Double Runner's case. So just understand that.
I understand.
Okay. All right. I'll expect full compliance with all the conditions imposed on that case, and we'll see you back before the court on the 26th of February. Actually, I have signed the rescission, so if you can give Mr. Double Runner a copy and Ms. Double Runner a copy before they leave.
Okay.
All right. Thank you, Your Honor.
All right. Thank you very much. And I believe that will conclude. Oops, Mr. McClone, Cimarron Dale Fruits.
And Your Honor, I stuck around to handle that. I don't have any information, unfortunately. I don't believe that this individual has been appointed counsel.
I would agree with you there. It's previously found in violation. For some reason the sanction is done.
Okay, we're going to jump back to Judge Boyd really quickly.
Also here.
I could do the
All right, February 12th. All right, and if you all want to do a B page, and then we'll come back on the matter with bond. All right, just have a seat. Who's here on Rodney Judge?
Justice President, Your Honor.
And then your witness, Mike Hernandez, I believe, is that your witness?
He said he's on, Judge.
Yeah, he's in the waiting room. So
Okay,
after we do this, we'll do it. Court is calling 2023 CR 10772, State of Texas versus Rodney Dwayne. How do you pronounce his last name? I'm sorry? Deutsch. Okay. Can I have parties announced for the record for the state?
Hank Wilkins for the state.
Defense?
Michael DeLeon for Mr. Deutsch.
Are you Mr. Deutsch?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No applications, Your Honor.
All right. Mr. George, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
Counsel, you were appointed on this case today, correct?
That's correct.
Are you waiving your notice?
Yes, we're waiving our 10-day preparation period.
And have you had ample opportunity to speak with your client?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, and with the visual offender enhancement allegation.
All right, Mr. George, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it? Did you sign it in all the appropriate places? All right, you're charged with a burglary of a vehicle third or more. And if the state is able to prove up the enhancements, the range of punishment for your offense will be anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yeah.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yeah.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he's competent, yes.
Mr. George, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Oh, thank you. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 6 years in the prison. There are no applications. They're taken in consideration. Grand jury number 812924 CM 115791. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
To the enhancement, both enhancement allegation paragraphs in the indictment, how do you plead? True or not true?
True.
State, any evidence to support the defendant's plea?
Your Honor, I offer State's Exhibit 1 in the attachment.
We have reviewed that, Your Honor. We have no objection.
Going to show you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yeah.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
And this guy's getting 6 years habitual auto burglary. Generally, these sort of crimes run with drug use as well. Whiskey 77, we did follow the sentencing right after lunch. We watched the sentencing for the flying inmate, Superman as we call him. He appeared in full restraint.
After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find both enhancement paragraphs true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just asked the court to follow the plea agreement, Your Honor.
All right. The court will find you guilty as previously stated. The enhancement's true. Sentence you to 6 years in the prison. Give you credit for any time served. Take in consideration grand jury number 812924 CM 115719. Is there anything else from either side with regards to sentencing?
No, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I'm not even from Pickles.
Okay, where are you from?
East side, Chicago, Illinois.
All right. Well, after your sentence is done, of course, you can go back there. All right. Good luck to you.
Thank you, Your Honor.
Thank you.
Good luck to you, sir.
Andrew Arnett. Is the attorney here for Andrew Arnett?
I don't know if 6 years is what that guy needs.
We're ready.
I'll let you finish.
Okay.
Okay. Renee Presidio. Is the attorney here for Renee Presidio? All right, then we're going to move on to Matthew Castro.
We're ready, Judge.
We're ready. Is this the Zoom guy? I think he's the guy who's on Zoom. Bring him in. Oh, no, different guy. Ooh, dressed nicely.
Good afternoon. All right, we're here for sentencing. Court is calling 2023 CR 8111, State of Texas versus Matthew Alec Castro. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Samuel Wiles for Mr. Castro.
And are you Mr. Castro?
Yes, Your Honor.
You had a plea of no contest to count 1 on October 17th. The court ordered a PSI and TAP evaluation. According to the plea bargain agreement,
Count 1 of what?
punishment is to be assessed at a cap of 6 years in the prison. The state is opposing your application, and they took several cases into consideration. All right, are both parties ready to proceed? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections?
No objection, Your Honor.
No objection.
All right, state, any witnesses?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor. Defense calls Mike Hernandez.
All right, Mr. Hernandez is appearing by Zoom. Any objections from the state?
No objection, Your Honor.
Any objections from you, Mr. Castro?
No, Your Honor.
And defense, it's your witness. I'm assuming you have no objection.
No objection, Your Honor.
All right, Mr. Hernandez, if you could unmute yourself, please.
Say it again.
All right. Could you raise your right hand for me?
Oh.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand. State your name for the record, please.
Mike G. Hernandez.
All right. Defense?
Thank you, Judge. Good afternoon, Mr. Hernandez. Can you hear me?
Yes, yes.
Thank you for being here. I know you're working. I just want, can you tell the court how you know Matthew Castro?
He worked for me about 2 years. He worked for me about 2 years. 2015, 2017.
And what does he do for you?
He started as a helper at the shop, and then he moved up to a welder's helper.
And what does that exactly do? What were his tasks?
He helps a welder with anything that we're doing, giving him grinders, cleaning up wells, setting stuff straight for him as the welder's going.
And we spoke during the bond hearing. Is he coming back to work for you?
Yes, I'd like to get him back. He was doing real good before he left. He started having some problems at home, so we had to let him go. But I want to reinvest what I had going with him and get him going again, get him back to speed where we're at.
And I'm sure you know, but when I talked to Mr. Castro and asked him if he was ready to go back to work, he just lit up. Can you tell the court what kind of worker he is?
He was on point in time, always ready to go. He always helped us out. And we actually, when he left, it was hard to replace him. So I really would need him back.
Thank you, Mr. Hernandez. Pass witness, Judge.
It's just a business thing.
Hi, Mr. Hernandez. My name is Hank Wilkins. I'm one of the prosecutors here. If I ask anything that you don't understand, just let me know and I can try and rephrase it, okay?
Yes.
So, can you give us the years that Mr. Castro, when did he work for you?
What years?
Yes, sir.
It was between 2015 and 2017.
And why did he stop working for you in 2017?
He started having problems at home, and I told him I couldn't. I needed somebody who I could, who could be more. I didn't want him dealing with phone calls and all that, because we're always working, always busy, and I needed full attention at work because it's very dangerous, some of the stuff that we do, and I needed him to be on more focused on what he was doing. He couldn't do it at the time, so I just had to let him go at that time.
Okay. And was that the stuff that was going on at home, is that in his personal life or was that court stuff?
I think it was just personal life. I didn't get too involved. I just know it was affecting my work.
Okay. And do you know anything about the cases that he's being sentenced on today?
Not too much. I just, I haven't heard too much about it. I just know that he was waiting to come back to work if it was possible, and I told him I could use him.
Okay. Thank you, sir. I don't have any other questions, Judge. Just briefly, Judge. Yes. Mr. Hernandez, you said problems at home, it was affecting the work, and you mentioned phone calls. Was that his wife calling the work, or what was that?
Yes, his wife kept on bothering him, and with us, it's very dangerous. Some of the stuff that we working with the tools are high power stuff, and you got to be paying attention the whole time.
All right. Thank you, Mr. Hernandez.
All right, any other questions of this witness?
No further questions.
All right, is the witness excused?
Yes, sir. Yes, Your Honor.
All right, thank you so much for showing up, Mr. Hernandez.
No problem, thank you.
Any other witnesses?
Yes, Your Honor. Defense calls Laura Rivera.
All right.
Another witness. This one's in person.
All right, can you raise your right hand for me?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Laura Rivera.
Defense.
Ms. Rivera, can you tell the court what your relationship with Matthew is?
His mother.
And can you tell the court, growing up, what kind of child was he?
Real good. He, my mom and dad helped me raise him. He always followed my dad and mom was around. Barbecue, fishing. We did everything. He would always help out, like when they were doing mechanic stuff in the vehicles. He would help out. He always wanted to help out.
And
they called him handyman.
Handyman?
He was little and they called him little man. Yeah.
And how is he in school?
He was really good. He wasn't gifted and talented. I know you hadn't heard that. What is it called today?
That's like AP?
Yeah, it's really advanced in his education. Mm-hmm.
And then after high school, can you tell the court what was going on with Matthew?
Well, during school, his older brother, my other son, had been shot in a drive-by, and I was in the hospital with him for a little over a year, but my son was fighting for his life for like 3-4 months. So he started taking it hard and kind of started, and then I was always with my son like 24/7. So him and my, she's 23 now, and my 16-year-old were kind of raised with my mom because I was focusing on my son. So he started messing up a little when I tried to, get him back. He started doing good. I took him to counseling and started taking classes. He had gotten through juvenile, but he's doing good. He was doing good. And then he got married and I saw him changing. It's like, it took a big toll on him. It was really, 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 really toxic, like really bad.
And you say changing, what do you mean?
Changing, like he wasn't himself anymore. He wasn't outgoing anymore. I would call him and he wouldn't answer. And he was a type that was always, he would call me or he would visit us. And at first she would come with her, but once she got her kids back, everything started changing. I think she started getting stressed out with that she had her 4 kids back and started taking it on him.
And how was Matthew with the children?
Really good. They love him. As a matter of fact, after the apparent assault that he did, she said she sent them the documents that she wanted him to be their father legally.
To legally adopt
Yes.
them?
Yes,
Okay.
but he had a good relationship with them.
And then you've mentioned your family. What kind of support system does Matthew have at home?
Oh, really good. He has his little sister that really looks up to him. Me and my husband.
And how does he help his sister?
Oh, with homework. Yes. Anytime she would get stuck, he would help her. He's really smart.
And then who is Elvia Saucedo?
My mom.
Okay. That's his grandma.
Mhm.
And then who is
She helped me raise him.
Mr. and Mrs. Joe Gonzalez?
Our neighbors.
Okay. And did you get them to create affidavits for Matthew?
Yes, I did.
Your Honor,
Just a quick little.
at this time, defense offers defense 1 and defense 2.
No objection.
Judge right now is reading affidavits from grandparents. This defendant has a lot of support. His mom's there. He's got family support.
Okay.
He's got his
Any other
boss.
questions?
I think there's going to be some sharp
And
words
since
from the
Matthew's
judge.
been home after he got out on bond, what changes have you seen in him?
Outgoing again, helping out, loves to eat, watch movies together. He's just outgoing again. He's himself again.
Back to his old self?
Mhm.
And
Yes.
can you tell the court why Matthew would be a good candidate for probation?
I feel like he's ready to move forward from his marriage and just have a life, normal life. Not
Sounds
arguing
something
and fighting.
domestic.
He doesn't have any kids or anything, so he still has a chance to work and just be a better person.
And he would live with you?
With me, yes. And then we are going to be moving to a new home soon too, so we're going to get out of the area. Yes,
Thank you.
I need him.
Pass the witness, Your Honor.
Thank you.
State.
Hi, Mr. Rivera. My name is Hank Wilkins. I'm one of the prosecutors here. So you've known Mr. Castro his whole life?
Of course.
Okay. So you were in contact with him when he got sentenced in 2016 to possession of less than a gram, right? He got
Right.
probation in that case?
I believe so, yes.
Okay. And he wasn't successful on that, was he?
No, he was,
And so he got sentenced at that point to 6 months, right?
yes,
And you were in contact with him in 2017 when he got sentenced on burglary of a vehicle third, right? You got 10 months there, right? Okay. And you were in contact with him back in 2014 when he got sentenced on burglary of a vehicle 4 months and 6 days, right?
yes,
And back in 2015, you were in contact with him when he got a year probation on burglary of a vehicle second or more, right?
yes.
3 vehicle
Do you know if he was
burgs
successful on that probation?
after 1 possession.
Sorry, I can't remember. I don't remember, I'm sorry.
Okay.
I'm too far.
So he wasn't successful on that, right? Or you don't remember? Okay. But would you be?
Okay, I don't remember, I'm sorry.
I'll stand over here so you can. So would it be surprising to you to know that he wasn't successful on that probation?
No, because he was younger,
Okay.
he was younger.
So he got 4 months, you got a 4-month sentence on that. And you were in contact with him in June of 2022 when you got an obstructing a highway intoxication.
Well, yes and no, because he's married, so he hasn't lived with me for a couple of years. 8
Okay.
years.
He got
So he's got 5
12
priors.
months there, right? He got a 12 months probation there, or he got deferred a month?
I know he got probation, yes.
Okay. So can you tell the court what's going to be different about this time?
This time, I think he's older. He has a better head on his shoulders now. He was incarcerated for 5 months this time, and I feel like he learned a lot. My mom had a heart attack like 2 years ago. And then
Sorry, just 1 second. Excuse me. There's no talking in the box to each other. Separate.
The inmates are talking.
All right, we're back on the record. You can continue.
So my mom had a heart attack about 2 years ago. She had major surgery a couple of months ago, and he's scared. He doesn't want something to happen to her, and he's not there. She helped me raise him, so she's like a mom to him. I feel like that's going to help him also not want to be incarcerated anymore. So I don't think he's going to do anything to go back.
What year did she have a heart attack?
2 years ago, it was 2021.
And so you're aware he's got several charges that we're here for today, right?
Yes.
Okay. And I know you haven't looked at this, but they did a report to help the judge decide. He says he doesn't have substance abuse issues in this. Do you agree with that?
I agree.
I pass the witness, Judge.
No further questions, Judge.
All right, thank you.
Thank you.
Next witness.
Your Honor, no more witnesses, but if you would allow, the defendant would like to address the court.
All right, I mean, he can address the court as a witness.
Yeah.
All right, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth, and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Matthew Castro.
All right, defense, any questions or no?
No, Your Honor.
State, any questions?
Sure, yeah. So Matthew, my name is Hank Wilkins. I'm one of the prosecutors here. We've seen each other before, but I've never introduced myself. So if I ask you anything that's confusing or you're not quite sure what I'm asking you, just let me know and I can rephrase it, okay?
Yes, sir.
Okay, so you asked, or you asked, you were here when I was talking to you a moment ago. And I went through some of the things that you've been in court for before, right?
Yes, sir.
And it looks like you've gotten opportunities on deferred adjudication, right?
Sure.
You've gotten opportunities on probation, right? Sure. And you're not always successful in that. Is that right? Do what? I'm sorry.
I wasn't successful.
You were not before.
Yes, sir.
Okay. So can you tell the court why you think this time is going to be different?
I believe that during that time, I was younger. I was going through it because of my marriage. There's no excuse for my actions, but just being in the state of mind that I was, I felt betrayed. I felt worthless. And I guess I wasn't thinking straight. I was younger. I was less mature. And at the time, prison wasn't like on the line, you know? So I was really just being a knockoff. But this time, now that I know I'm facing prison, I had nothing but time to think while I was in jail. And I was thinking about my grandma, my mom, my sisters, everybody. This time will be different because it's my last chance. I'm facing prison right now, and I don't want to go. Honestly, in my heart, I know I'm not a bad person. I don't wake up every day thinking, who am I going to rob or kill or shoot today? I'm not somebody that's a danger to the community. And my whole neighborhood loves me. They're all older people, and since I was little, I've always helped them. And I really believe it. But if you give me one more chance, I'll succeed. And if I don't, I'm not gonna run. I'll turn myself in, and y'all could do what y'all will with me.
So, you said you're not a danger to the community, but do you think that some of these charges that you're charged with might make people have the idea that you're a danger to the community?
Maybe in some light, yes.
So you're a felon, and one of these charges is felon in possession of a firearm. That sounds dangerous, right?
Yes, sir.
And a couple of these are burglaries. That sounds dangerous, right?
Sure.
Okay. What year did you get married?
In 2019, March 15th, 2019.
Okay. So I know that there was some testimony that some of this might be tied, some of your criminal actions might be tied to your marriage, but.
But I was with her way before that.
Way before that? Okay. Because, if you got married in 2019, but some of these charges are from before that, like how long were you all together?
About 7, 8 years.
And are you taking responsibility for your actions, or are you blaming your ex?
No, I'm taking responsibility. Like I said, I'm not trying to justify my actions, but at the current state of mind that I was compared to now, I feel like I'll be a lot more successful because now there's no more. That's it. Like I'm saying, now I'm facing prison, and I don't want that. I don't want to go and something happens to my grandma. Like I said, sir, if you give me one more chance, please, and if I mess up, which I know I won't, I feel real confident this time. Y'all could give me the max if y'all want. You know what I'm saying? Because I know I'm gonna do good. I have a job lined up. And my plan is to pay if I can pay restitution to the victims of my crimes, I am. I'll do whatever needs to be done to show that I'll be successful at this, and to show that I have a heart and that I'm not just somebody that wakes up every day thinking, how am I gonna F up the world? You know what I mean?
So did Mr. Lyles go over this with you? This is the pre-sentencing. They do a report for the judge to help her make a decision. Did he talk to you about this at all?
Yeah.
Okay. So one of the things that was in here was, you don't think you have a substance abuse problem. Is that still something the same, that you believe that's still?
Yeah, I'm not, this wasn't all because of judge, it was because of what else I did.
I passed the witness, Judge. Thank you.
Just briefly, Matthew, is there anything else you want to say to the judge or to the victim?
To victims, I'm sorry for what I've done. And if I could meet you in person and tell you sorry in person, I will, and I'll pay the restitution. I'll show you that I was immature before. I was letting the situation get the best of me. And now that I'm facing the prison, that's enough. I'm not gonna mess up no more. It's like, there's no more slaps on the hand, basically. And I had to be here with my grandma too. I just talked to her the other day. She already had the heart attack. And I don't want to be incarcerated. That's my second mom. You know, and I'll do whatever the court needs me to do, what they want me to do, community service, everything. I'll do it to show that I'll be successful. And Your Honor, if I fail to do so, which I'm confident that I will not fail, I'll come back, surrender myself, and face you again, and you can do what you will with me.
No further questions, Judge.
She
All right,
can
any
do
other
what she
questions?
wants right
No
now.
questions, sir.
I have a question.
Yes, ma'am.
Why did you commit this crime?
Why did I commit this crime?
Mhm.
At the time, I was going through it with my wife. He kept all my belongings, left me with literally nothing. And I was just,
So why didn't you go to her house?
excuse me?
I said, did you go to her house and take your stuff back?
No, she don't get to me.
All right. So instead you went to a stranger's house that you don't know, and you went in to take their stuff.
It was a RV, man.
All right. So, and it's a stranger's RV.
Yes, ma'am.
Which, what we were taught in law school, anything really can be a habitation, right? If you're living in it, a car can be a habitation.
Yes, sir.
So an RV is a habitation. So why are you taking their stuff? Because your girlfriend took your stuff and wouldn't return it.
I was thinking of, I needed some kind of money, some way real fast. I was just being immature about it.
Why do you call your mom?
When I call my mom?
Mhm.
Because I didn't want her to get her involved with me and my wife's problems, because my wife was raised to the point where she ran my vehicles, and she tried to keep the keys away from my mom from her vehicle one time, because I let them there. There was already a lot of drama going on with her and my family.
So why do you, yes. So why do you call your grandmother?
I don't want to put her through the stress as well.
All right. So you decided to put a stranger through this stress of having their items stolen.
Yes, it was a horrible mistake. And like I said,
Nope. You made choices, not mistakes. You know what a mistake is?
something by accident.
No. Let me just tell you.
Let me buckle up.
It's raining outside. Here's the example, Diana. Weather forecast. I don't think anybody really anticipated it was going to rain today.
Thomas did.
But
Weather watch.
let's say you know it's going to rain today. Your mom tells you, your grandmother tells you, and so you come to court with an umbrella because you know it's going to rain today. People are coming in wet. You have your umbrella. You go outside and you're like, good thing my parent called me to say it was going to rain because I'm prepared. Now, let's say you don't know it's going to rain. You come to court and you see people coming in wet and you say, shucks, I don't have my umbrella. There's somebody sitting next to you who has an umbrella and you take it. That's a choice. Now, if you know it's raining and you bring your umbrella and you have a black umbrella and the person sitting next to you also has a black umbrella and you leave and you take an umbrella, and when you go outside and it's raining and you open up the umbrella and you realize this is not my black umbrella because I have initials on mine and it's not here, that's a mistake. So you going into that person's RV and taking their items, those were choices you made. That's not a mistake. You didn't mistakenly think, oh, this RV is the same color as mine. I'm a little bit intoxicated right now. And I know I always leave the door open and this RV's door is open. Let me go in there. You knew that wasn't your RV. You understand?
Yes, sir.
So you made a choice. So I'm trying to figure out, why did you choose to break into somebody's RV and take their items? And this whole thing about I'm going through things with my wife, that's not going to cut it. Because everybody here has had a bad problem, I'm sure, where they've gone through a bad relationship. That doesn't mean they go out and commit crimes and then want to pass because I was in a bad relationship. So why did you go and take their items?
Sure, I needed some money.
Money for what?
Clothes.
Well, you could have called your mom and your grandmother and asked for clothes. You telling me your mom wouldn't have given you clothing?
Still would have if I would have told her. The
Okay.
situation. Yes, ma'am.
So I still don't understand. So why are you breaking into somebody's RV?
To take their belongings to sell to get money
Money for what?
for some clothes and everything I needed that day.
Okay. All right. Any other questions?
No, Your Honor.
And I read in the PSI report, he said he didn't think he would get charged. So I'm assuming he didn't think he would get caught.
Yes, ma'am. At the time, my immature thinking.
I'm sorry, what?
At the time, yes, I was being immature about my choices.
And you say you were being immature. How old are you?
28, ma'am.
All right. And this occurred. Let me pull up the date.
You did not answer correctly.
What's the offense date on this?
March 8th, 2023.
All right. So anything else from either side?
Nothing from defense, Judge.
Nothing further.
All right. I'm not going to grant his application. I'm going to find him guilty. Does anyone wish to speak to the cap?
Yes, Your Honor. And Your Honor, and I appreciate the court's patience. Any delay in this case has been absolutely my fault and not Mr. Castro's.
Oh, I don't hold delays against anyone.
I'm not just saying, Judge. So Mr. Castro, he actually pled on the first day that he received an offer. Since the time I met him, he's taken responsibility for this. I know he's made bad decisions before and he has a history, but he wants to change his life. He has a welding job set up.
He's
ready
That's my call.
to get back to where he can contribute to society. And if this means that he has to do some time, he's willing to accept that. We would ask just for the 2 years, because whenever he does get out, Judge, I know he's going to be able to go get a job, be a contributing citizen. He has removed him. I can attest he's removed himself from a bad situation. You heard Mr. Vera testify how he's changed. I could even see that. I've never seen a client, when I mentioned working, when he was getting out on bond, how them light up and how excited they were. He's the only client I've ever seen that happen with. So Judge, we just ask that you give the minimum 2 years, let him do his time and be able to get out and contribute to society.
All right. And in the PSI report, I see that restitution for Mr. McDermott, DERMAIN, that was never given. The only restitution amount I see is for Richard Pacheco. And that's for the expense of the tow truck and fixing his truck. Is there going to be any objection
Nothing from defense, Judge.
to the $800?
Your Honor, I think we've tried to reach out to Mr. McDermott and haven't been able to get a response as to about restitution, Judge.
All right. And state with regards to sentence?
Judge, it's a cap of 6 years is what we agreed to. We're asking for the 6 years. As I talked about with some of the witnesses, these are inherently scary crimes. I don't know if there's a better way to put that, but breaking into where somebody lives, that's a scary thing. The reason that we have laws against felons walking around with handguns is because it's a scary thing. It's inherently a dangerous crime, Judge. These are not victimless crimes that the defendant's accused of. So we are asking for the 6 years, Judge. And these are, like the court talked about with the defendant, these are not mistakes. These are choices the defendant made. So that we're asking for the 6 years, Judge.
All right. As previously stated, the court is finding you guilty. I'll take into consideration 2023 CR 8110, 2023 CR 8594, 2023 CR 9165. There's to be no contact with Allan, ALLAN, McDermott. Is it McDermott or McDermade?
I think it's McDermott, Judge.
All right. No contact with Allan McDermott or either McDermade, DERMAIND, or Richard Pacheco. There's to be restitution of $800 to Richard Pacheco. Court is going to sentence you to 5 years in the prison and give you credit for any time served.
And the cuffs are on right there.
And Judge, we would ask the court if Mr. Castro could have some time to get his affairs in order and then turn himself in. He's been on bond and hasn't had any issues.
No. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
No.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Castro, I want to let you know I did review everything and take in consideration your employment and that you're saying that you've changed. When you go to prison, do not become institutionalized. At the prison, you can still pick up different trades. You can actually get a college degree at the prison and it's free. So you can work on that. And then when you get out, I'm sure Mr. Hernandez, if he was willing to take this risk with you working for him, I'm sure he will do it again. When you get out, stay on the track to become a welder. You understand? All right, good luck to you. I don't have the dismissals.
Fill those out, Judge.
Okay.
I think he
Diana?
really thought he was going to get probation.
No, they don't allow that. Here you go.
His mom wants to talk
Those
to
are
him.
the exhibits.
And the judge said no.
This is done. And on the other ones, I'm just waiting for the dismissals.
We are ready on our net now. There's a quick.
Okay. All right, you all didn't put a bond amount on this.
Oh, the 5,000, Judge.
So that seems pretty harsh, but look at his priors. She said she's
Andrew
taken into
Arnett?
consideration 3 prior vehicular burglary.
Oh, this is not
charges.
on the doc record. This is just a reset.
It was 5 years, a possible of 6 was the cap. Defense wanted 2. Ooh, Adidas. Not quite the court attire the judge would want, but at least a respectful pose.
Good morning. Good afternoon.
And the last thing was the only thing we weren't in agreement with. Only because, and,
With the GPS tracking?
right, only because it wasn't put on when he first got out.
Well, I'll keep GPS tracking and I'll just ask that fees are waived.
Okay.
All right, where are we on Mr. Arnett?
Judge, we, defense counsel and I have been conferring, I believe it's our second setting, Judge.
So were you able to tender an offer because an offer was due today?
I was able to tender an offer, Judge. We would ask for a reset. I think he'd like to discuss the offer a little bit more with his client.
Okay. How much time are you asking for, counsel?
Your Honor, we don't need a lot of time. He actually wants to consult with his family, not me. I've consulted with him. So whatever the court wants to give him a couple weeks is fine.
Okay, how old are you, sir? How old are you?
37.
Oh, all right. So we're going to come back on January 11th.
It's 3 days.
That's going to be your plea deadline date.
That's enough time, Judge. I do appreciate it.
Let me give you a reset form.
Okay.
Do you have a reset form, Jessica?
Montemayor, Martinez Abel, Rodney.
Got a glitch in the feed for my little camera box. Occasionally it just flashes. Are you guys seeing that, or is it just me?
Oh, I don't know where they are.
No, the one here, around the corner. We are there.
He just doesn't know if he was done or not.
I think that may be, let me see.
You saw the flashes? Okay. What I'm going to do is I'm going to power off that switcher, not my main switcher, just that one. Let's see if I can fix it.
Come here. Oh, over here.
Oh, that's because it's like it's cold here, but it's not.
0.036.
And your client was late?
I wasn't aware of that, Judge. Thank you for letting me know.
Okay.
I'll discuss that with him.
Okay, of course, now I'm no bueno.
Yeah. If
Thank
you
you,
have
Judge.
your client sign that, and then turn it in, then he's excused.
You're up.
Diane, are you ready? All right, are the parties ready on Amber Lopez?
There's my green screen.
Court is calling 2023 CR 10151, State of Texas versus Amber Nicole Lopez. Can I have parties announced for the record for the state?
Hank Wilkins, who say your
Defense?
Matthew Brown for the
Now I
defense.
broke everything.
And are you Miss Lopez?
Yes.
Counsel, have you received all the discovery? Did you review it with your client? Have you received all the discovery and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lopez, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it? Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Lopez, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonition. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Mm-hmm.
You need to say yes or no. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand by entering this plea you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. No application for deferred adjudication. State recommends community supervision. They're taking in consideration NM 703375. There's to be restitution to Elmendorf Police Department for drug testing. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
There have not, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
No objection, Your Honor.
All right, you may continue to confer. Showing you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same.
While she's reviewing, I'm finding my background again so we can get my courthouse back like this. Oh, thought I had it back. I need switcher to, oh, I'm in black. No wonder. Let's just say camera 1. There's my green screen. MP1. Put bars behind me. That doesn't look really cool, but all right. You like the blackness, says Reverend Beasy. Can we submit new background? Of course, screeners. They have to be preferably in 1080, the 1080p resolution. Do you know what that means? As far as the pixel size. So it goes edge to edge. And it has to be something that you have the rights. You can't like steal someone else's that's a copyright.
All right, after
You can't
reviewing
say
state's
Disney or
exhibits
something.
1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, if you would look at or I'll just refer you to the police report. The weight in this case was only 5.3 grams. So when you consider the statute being 4 to 200, this is on the very low end of that spectrum. We just ask you to follow the agreement based upon that.
All right. So what is your drug of choice?
Meth.
Sorry.
How often have you been using?
Not often.
What does that mean?
It was on and off for like maybe a year.
You trail off, you said on and off for maybe, and you didn't give me an answer.
A year, he said.
And what were you using?
Meth.
Who is Ramon Garcia to you?
Friend.
Do you have any children?
Yes.
What are their ages?
10, 4, and or 10, 7, and 3.
Wait, 10?
7 and 3.
And who are your children with?
They're with their dad right now.
Is Child Protective Services involved?
No.
When's the last time you had employment?
A year ago.
Doing what?
I worked at a store by my house. It was a tobacco store.
Why have you not been working in over a year?
I was trying to find a different job. I went to school for aesthetics. So I was doing school and I was trying to find
What
a
does
job.
that mean, school for aesthetics?
And I'm an esthetician.
Oh, okay.
So I was trying to find a job in a salon.
Okay.
And
All right. Is there anything else?
No, Your Honor.
All right. The court is going to sentence you to 6 years in prison, suspended and probated for 6 years, taking in consideration 703375. There's to be restitution, if any, to El Mandor PD for testing. 200 hours of community service restitution. I'm going to want parenting classes once that's completed. The restitution hours for community service will be deemed satisfied. There's to be regular reporting by Zoom or in person. I'm going to want a referral to felony drug court. That's to be done in custody. I'm going to want a TAP evaluation. That's to be done in custody. If felony drug court does not accept her, follow whatever recommendations that the TAP evaluation sets. There's to be proof of employment within 40 days of release. No employment as a home health care provider or with minors. There's to be no contact with Ramon Abraham Garcia. There's to be no unsupervised contact with minors. Counsel, that may change once she completes the parenting classes.
Yes, Your Honor.
I'm going to want field visits 1 time per month until further notice. Probation, if she, of course, is accepted into drug court, then drug court will monitor her. And I'm going to want the UA hotline and 90 sober meetings in 90 days. Probation, is there anything else she needs? Is there anything else you need from the court to be successful? And there is a request for a $2,000 fine. I'll do a $2,000 fine, but that'll be probated. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. If there's an issue with probation, let the court know. You can always come in here. But you're going to have to get clean and sober. I always tell people they need to do it for themselves, but you have an extra person you need to do it for, which is your children. Your children hopefully want you in their life, but you can't be in their life if you're not clean and sober. You understand?
Yes.
All right, good luck to you. Anyone else ready?
Who else wants to be judged by the judge today? Anesthetician. This is somebody who does like waxing. I've waxes and stuff like that. Never done that. I probably am a great candidate.
All right, the last person we have on the docket is Renee Presidio.
Yes, Your Honor, I'm here. We just worked something out, Judge.
Okay.
Paperwork already had half of that.
All right, awesome.
Last minute deal.
Preciado.
Preciado. Okay, Preciado. I'll remember that.
I don't know which one of the inmates was the digger, but the judge did not mention it when they came up to the bench that I saw. A whole segment off the record with Judge Boyd. That could be its own show. That could be its own podcast. Oh, somebody hacked and into DeSanto's channel. Whoa. Judge DeSanto? And YouTube shut it down. When did that happen? We've watched Judge DeSanto on here, I think. Name's familiar. I think we watched her within the last couple of weeks.
Vashawn, who is that, Mr. Brown? Oh, Mr. Cuellar. Where's your client? Kayla Connor.
I haven't seen her for many months, Your Honor.
Okay.
Did they pick her up?
No, they haven't picked her up yet, but there's a warrant out for her.
We spoke for a long time. The last time I saw her, which was, like I said, at least 6 to 8 months ago.
Okay.
And, I explained to her everything.
Okay. All right.
This must have just happened. About 2 weeks ago.
All right. Just give me 3 minutes. I'll be right back.
Man. That is crazy. I know judges make a lot of enemies, right? There are people who appear before them that have a lot to say and some hard feelings. But the judges just learn to live with that. But if somebody hacked her channel and then showed some inappropriate material, got her channel shut down. That's a bad deal. Because that's crazy. I believe the channel was shut down because it violated the terms of service, but it was a hacker who was showing inappropriate material on her channel. They signed into someone who was on the docket, and then when she activated the feed, they were showing other stuff. Wow. Okay, so that could be that might be illegal. I mean, and I'm just saying that could be a crime in and of itself. Yep, they were playing farming simulator, and there was corn that was shown apparently. Who does that? Somebody who doesn't like the judge and who knows that they're streaming live.
There's a lawsuit.
Yeah, I can't see her channel either. I just did a quick search, and I can see like Squishy Gardner and Credence and Mikey and Law Talk with Mike and everybody else who's got stories about her channels, but nothing else. It's gone. Man. Zoom was plagued with lewd content. Nice. No, it's not a copyright strike. This is typically that sort of material would get you a violation strike from YouTube directly, saying, and that can shut you down depending on the content very, very quickly, as it sounds like it did. Oh, Richard Chambers, yeah, there's all sorts of work they can do on the court side to track this down and see exactly who that was. Hey, ma'am, how are you doing? I'm not going to Google it. It's not. Oh man. Let's see, Judge DeSanto has a bad day. Let's see who's did this one. This was Colin, definitely not Cromwell. It was talked about it. Crazy. We've seen. I mean, this isn't alone. That's not just her. Michelle Troconis. Why is that name so familiar? Somebody refresh my memory. Which case that is? Lots of speculation that it could have been an attorney she excoriated in public. It could have been anything. It could have been any number of defendants that are now out. People that she just sentenced. That they. I mean, the information that goes to a defendant or a witness or an attorney about how to access the court feed, that once that information gets out to access it as a participant, all you need to know is what's coming up on the docket, and basically contact the court pretending to be somebody who rightfully should have access, and it's granted, and then in a moment, boom. Yeah. Brandy's covering that one. Brandy's covering the Troconis trial. Awesome. Great. What state is that judge in? What state is DeSanto in? Is she also in Texas? I don't remember. DeSanto managed to track down someone that called in that refused to say where he was and turn himself in. So now I know they can find Zoomers. Oh yeah. Living Ghost, let me just say, I used to work in the big data world. Meaning I would work with software like Splunk, for instance, if you're familiar with what Splunk is. Splunk takes data in any form from any tool that records data. Everything from literally a smart device. If it connects to the internet, if it has some sort of computer, if it has a login, if it has a password or a swipe card or anything, you can take all this data and dump it into one big pot and connect it different ways, and you can extract from that data and basically paint a picture that doesn't exist, but you can do fill in the blanks. It can take little bits of data. Say, for instance, I'll give you a quick example here. Let's say you have you have somebody who's working at your company, and they have a login on your computer system, and they log in and they have a VPN so they can log in from home. In some situations, my software, just because of the information that it tracks and what I can find out about publicly using the network, I can tell if that individual sped to work that day. No, seriously. If they logged in from home and then we're told they have to come in, I can see the timestamp they logged in. I can geolocate their IP address and then see the timestamp they logged in at work and do the math to see if they could legally cover that distance in the amount of time they did. So that's what big data can do. It can take little bits of information that seem to not be connected and put them together, and you can find out lots of other things that are very, very useful. So and finding something like that, computers, if they connect to each other, if they talk to each other, they leave a record. They leave a trail. They leave breadcrumbs and more and more and more. This is RA's umbrella story. Now you know. So don't speed to work. Anyway, it sucks that somebody would do that, honestly. You've seen that. The attorney likes to chat with the judge. Yeah, I think they're working out a deal on something right now, but the judge's mic is off, so we'll never know. Let's see, make sure to read all the messages from Toxic and Mod Chat at some point today. Possibly worth not missing. I've got so many messages. Okay, I'll review that. Thank you very much. All right, used to use Splunk a bunch of years ago. Greeners, it's good stuff. Splunk is it's very expensive to use, especially if you have, like, you're in a big data center, ingesting all that data, and then depending on how many search heads you have running and everything, it can get very expensive to extract data that way. All right. I think we're about done. It's 4:20. My kids have reminded me that there's a football game tonight. And Ivan, I know you're big into football. I guess the championship football game is tonight, right? So your coveted Packers. What school is that? I don't remember. What school are the Packers, Ivan? It's 4:21 now. Yes, I think Ivan left. He's not rising to the bait when I try to tell him that his Packers are a college school. I tried. I was gonna wind him up just a little bit. Anyway, I believe there is a college playoff game, an NCAA playoff game. So my youngest son is going to hold his football and watch the game with me. He loves watching football with me, even though he does not understand the rules at all. But we're gonna do that. He's taking it really hard that his mom's gone, so we're gonna watch some football tonight and run with that. Use Splunk on my DCs, tens of thousands of devices, mostly for incident management. Good stuff. I love how it can tie in with so many other tools. Let's see, Michigan. The Packers are the youngest team in the NFL, and they're in the playoffs. Ivan has been singing the Packers' praises all day. I've been trying to sort of ignore it and not highlight it, but he is a proud fan, very proud fan. Hey, let me explain this really quickly. Judy M. The last, let's see, the Steelers were playing. I don't know who the Steelers were playing. There was a kickoff. I think it was a kickoff, and the ball like bounced, and instead of returning the ball, the returning ball player, the guy who could have caught the ball and returned it back, instead he like ran out of bounds, left his foot out of bounds, and reached in and touched the ball. What in the world was that? What happened? What weird rule was he exploiting to get a penalty on the other side? Does that mean the ball went out of bounds? Technically, because his feet were out of bounds when he touched the ball. That was, anyway. All right. Who are you hoping wins? I just hope it's a good game. Really, I don't know. Who's Michigan playing? We won. Steelers. Says Lynn Hoke. It's a strange loophole rule. Paula, you don't understand either. Packers, I thought, was an NFL team. They are. I was just winding up Ayden. Not sure if he's here. I think he's working in the store or something. Michigan State, Spartan fan, but when Michigan team is in the playoffs, it's Michigan Wolverines versus anyone. The ball was out of bounds. So that means that they have to re-kick it, or they, a 5-yard penalty or something like that. I don't know. I used to film NCAA football, college football, which is a blast. I love it. I'd be the guy up in the scaffolding on one end of the end zone. And if you're familiar with filming football, that's the most difficult position to work, because you've got depth of field issues across the whole field. So you're zooming in, which oftentimes will compress the image in your viewfinder, and then you have to focus as the ball's coming towards you and away from you, and pan back and forth. Whereas somebody on the sidelines, they basically just set their focus for the field, and they almost can just hold it and not have to adjust their focus at all, because everything's pretty much the same distance away from them. But anyway, all right. Let's wrap it up so I can go watch football with my son. And he'll be happy, and we'll all be happy. Sorry, Paul Mack. Cachette's a Vikings fan, Ayden, and I like to give her a hard time. Good. Most people don't enjoy hockey because they can't see the puck. It goes too fast. If you were to use like an inflatable ball, you better watch, instead of the puck. Make a little foam ball, like a Nerf ball or something, and make it bright instead of dark. That would be beautiful. That would work. And then we can follow it. So, all right. Thank you very much. It's been a fun day today. We're excited to have a new court case coming up here soon. So hopefully very, very soon we'll be kicking off a new case, and we'll be able to announce that with you guys and follow that all the way through. So thank you. UConn Cowboys won the NCFE. What time tomorrow? Probably 9-ish. Now, here's the thing. I've got to go pick up Mrs. R.A. tomorrow. And so if it turns out I have to be on the road, say like at 9, then I'll put a post out in the community page and let you know that I'm going to go live maybe in the afternoon when I get back. Anyway, if they used an inflatable ball, my career would have lasted much longer. Live hockey is great. I love it. I went to watch a hockey game. It was actually, I went to watch a fight and a hockey game broke out. I like those full contact sports, but not participating. All right, tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again, which will be tomorrow-ish, 9-ish, I think, unless Mrs. R.A. says otherwise. And then I'll let you guys know in the community page. I'll make a post out that way. You guys have a wonderful afternoon. I'll see if I can fix this flashing thing. Be good to each other. We'll see you tomorrow. Bye-bye. For those that are still here, I'm going to redirect us over to Dr. Joe. Yes, I'm still here. I haven't gone anywhere. Hang on. Looking for Dr. Joe right now. Hang on. There we go. It's coming up tonight, you guys. Enjoy it. We'll see you.